Background to lawful processing criteria. The GDPR requires controllers to process personal information lawfully, fairly, and in a transparent manner. There are 6 lawful bases, and these are: number 1, consent; number 2, fulfilling a contract; number 3, complying with a legal obligation; number 4, protecting the data subjects and their vital interests; number 5, performing a task in the public interest; and number 6, the legitimate interest of the controller or a third party when balanced against the rights and interests of the data subject. Article 6 of the GDPR lays out the criteria that must be met for lawful processing. If a controller is unable to rely on one of these bases for processing, it will be unlawful to proceed unless the controller can establish some exception, such as processing personal data for journalism or research purposes, or for free speech, or some other public interest. Article 7 sets out the conditions that must be met when relying on consent. Often it may not be the most practical lawful basis to pursue for data processing and beyond certain specific activities, such as for marketing purposes. It is frequently not most commonly used. Article 8 provides further requirements where consent is relied upon when offering an information society service to a child. Consent is frequently at the heart of data protection and privacy laws. Giving a data subject the opportunity to choose how and when their personal information is used is a feature of best practice.